Hello and welcome to a special interview for The Wire supported by Glenlivet Books. Today we tackle two critical issues. Is the law of contempt being misused? And is there a case for rethinking the law almost entirely? Those are two key issues I shall raise today with a lawyer that many consider perhaps India's best. He's also a prestigious Queen's Counsel in Britain, from where he joins us today, Harish Salve. Mr. Salve, before I ask you questions about the law of contempt, let's start with two cases of contempt which are being heard by the Supreme Court. The first is to do with the comedian Kunal Kamra. The Attorney General has decided that Kunal Kamra's tweets, two of them, are contemptuous. The first tweet says, "Honor has left the building." He means the Supreme Court long back. The second tweet says, "The Supreme Court of this country is the most supreme joke of this country." Now, do you see those two tweets as contemptuous, or do you think they're better understood as satire, or perhaps a reflection of the way the Indian people think?
The two issues which we need to keep in two separate silos, Karan, is one is are the tweets contemptuous, and the second is, should the Supreme Court do something about every contemptuous tweet? By themselves, the tweets are clearly contemptuous. I don't think Mr. Kamra represents the perception of Indian society on what the courts have become. This may be his perception of the Indian courts. The second is, as we always said, you can criticize a judgment, you can criticize the institution, but the moment you question the edifice on which it stands, then you are questioning the credibility of the institution, not of the judge. So theoretically, if you see what he has said, he is saying that the Supreme Court has lost its independence, and the court is not deciding without fear or favor, as the judge takes his oath to do, but is slanted and deciding in favor of a political party. I think he used certain aspersions of that kind. By itself, is it contempt? Yes. Speaking strictly for myself, would I have taken notice of it? No. Who is this gentleman? And what is his credibility? And why must I believe that people of India will lose respect for the court because Mr. Kamra says so? So it makes a lot of difference as to who is making this comment. The world has changed from the days of social media. Today, each one of us is a publisher in our own right. Each one of us can use the blog, Twitter, and I don't know what other platforms are available. Facebook, I suppose. I don't know much about these. But we can use these to express our views, and immediately, the moment somebody says something, it goes on to public domain. And it becomes a publication of an opinion. We need to rethink how seriously we take social media.
Okay.
Just because some chap on social media says something which by itself may be contempt, do we need to bother about it, or do we need to, as one English judge said, grin and bear it?
You've made a very important distinction, and I want to bear that in mind as we go through this conversation. The distinction is between the content of what was said, which in the case of Kamra's tweets, you believe is contemptuous because it's questioning the very foundations, the very edifice of the Supreme Court and its independence. And the other point is whether one should bother in the case of Kamra. Who is Kamra? Why should we care about his views? And why should it matter to us what his views are? Let's take up the second issue a little later. I want to stay for a while with the first issue, i.e., is the content contempt? I'm going to quote to you what the Attorney General said when he granted permission for Kamra to be prosecuted. These were Mr. Venugopal's precise words. "This is gross insinuation against the entirety of the Supreme Court of India. The Supreme Court of India is not an independent and impartial institution, and so too its judges, but on the other hand is a court of the ruling party, the BJP, existing only for the BJP's benefit. That's Mr. Venugopal's interpretation or understanding of these two tweets. Do you share it? Would you go as far, or do you think he's gone a bit too far?
I let's be sure we are talking of the same subject matter. I saw the two tweets which I think one of the legal sites had picked up. One showed, I think he put the BJP flag on the Supreme Court.
No, forgive me, I'm interrupting. That is Rachita Taneja's cartoons. I'll come to them in a moment's time.
Right.
I'll repeat the two tweets to you. The two tweets say the following: honor has left this building long back. This building be the Supreme Court. And the second tweet says, the Supreme Court of this country is the most supreme joke of this country.
Did they have? I'm sorry, I'm not very sure of what I have in mind. I had that flag of BJP in mind, and that wailing the Supreme Court in the BJP flag. If this is what he has said, well, it is definitely contemptuous to say honor has left the building, because you're again attacking the building. But I don't know in what context it was said. Did he give a context in what he was saying this? I think it was in the Arnab Goswami.
It was indeed. It was indeed.
So if the Attorney General who saw it read it at the time as an implication that the act of the Supreme Court is dishonorable and the act of the Supreme Court is leaning in favor of a particular journalist because his views align with the ruling party, or at least it's perceived to align with the ruling party. If that was the suggestion, then the Attorney General is right. I mean, one may use stronger language or one may use language which is more neutral, but the Attorney General was right.
You're making a very interesting point. The Attorney General is basically right in his conclusion that these two tweets by Kamra are contemptuous because they suggest that the Supreme Court's act is dishonorable, because they suggest that the Supreme Court is leading in favor of the ruling party. However, you did also add that different language, less strong language, could have been used by the Attorney General, but language is a matter of words. The content you agree with. You may disagree with the expression of that content by the
I have my own style of writing English. You have your style of writing English. We write English in very different styles. I've been working here now for 3 years. I've had to unlearn my English and learn the language of understatement. That's how the British write their English.
You would have used the understatement, which the Attorney General hasn't. Let me now.
Indians are more passionate. Indians use stronger language. As when I used to, way back in India, when I used to write, I wrote more passionate stuff. Now it's more satire and it's more sarcasm, and it's the British understatement.
We in India go for the hyperbole. The Brits go for the understatement. Let me quote to you what Kunal Kamra said in his own defense in the affidavit he's given the Supreme Court. He says, and I'm quoting him, "I believe that constitutional offices, including judicial offices, know no protection from jokes." He adds, "Jokes are not reality and don't claim to be so." And finally, he says, "Just as the Supreme Court values the faith the public places in it, it should also trust the public not to form its opinion of the court on the basis of a few jokes on Twitter." How do you respond to that defense?
I agree with the third statement, not with the first two. Maybe I'm a stuck-up old fool who finds nothing funny in these comments. I would search very hard, but perhaps in vain, to find humor in any such statement. Having said that, if Mr. Kamra is saying, "Look, I'm just a clown, nobody takes me seriously," well, he just may be right.
Okay. Let me now come to Rachita Taneja, and I'll say for the benefit of the audience that when you gave your first answer, you had Rachita Taneja in mind, although I was questioning you, in fact, about Kunal Kamra. But for the sake of the audience, I'll briefly explain what is contemptuous or deemed to be contemptuous in her case. In her case, it's two cartoons. One cartoon depicts a person with a mic in his hand speaking to the Supreme Court while the BJP is listening, and the person says, "Tu janta nahi, mera baap kaun hai."
Yeah, I've seen that.
And
That's the one I thought this fellow had done.
the second cartoon is a drawing of the Supreme Court with a saffron flag on the top, and the caption says, "Sanghi Court of India." In your
So
eyes, these two cartoons, are they satire? Are they contempt? Are they just criticism?
I would borrow the Attorney General's words for these two. Clearly, I would borrow the Attorney General's words for these two. This again, the defense can be that this young lady said, "Forgive me, for I know not what I say." But the if you take the, as I said, if you take the question of contempt and not whether it is worthy of being treated in the contempt jurisdiction, if you take the words, they are the most grossest form of contempt. You are now telling what you're trying to tell the people of India that by a particular decision, the Supreme Court has established that it has lost its purpose of existence because the court is supposed to be an institution which acts collectively as well as individually at the judge level without fear or favor. You're saying they're acting in favor and obviously out of fear or political alignment or both or worse. So this is the most damning indictment of the court, and it is definitely contempt.
Very briefly, I'll quote you what the Attorney General said in the case of Rachita Taneja's cartoons when he granted permission for her to be prosecuted. He said of the first cartoon, he said, "An impression is created that the BJP is somehow interested in protecting Ornav Goswami and has prevailed upon the Supreme Court to do so. Of the second cartoon, he said, its intention is to denigrate the Supreme Court and lower its authority in the eyes of the public." I take it here, not only do you agree with the content of what the Attorney General said, but you would agree with the language he's used as well.
I would have only added the word, and the conduct is disgraceful.
The conduct of Rachita Taneja?
Disgraceful.
So you would have actually been stronger in your language than the Attorney General in this instance. Okay.
This doesn't even pretend to be humor.
In other words, the excuse or argument that this is satire or joke doesn't hold.
I mean, maybe it's a discussion for another day, Karan. But what worries me today is, we are having this, and I mentioned this on the other channel the other day, and this is again a debate for another day. I see a growing, and it worries me, I see a growing binaryism. Today, either there is a group of people who believe that either the Supreme Court decides the way they think it should decide, or the Supreme Court is dishonest. They have left no space for thinking, and there may be another honest person who may think some other way. And this binaryism is what worries me, because this, in any institution, challenges the existence. So this is a growing phenomena in the world, not just in India.
Absolutely. You're making a point, but it's a different point. But the point you're making is that there are people who believe that the Supreme Court is right if it agrees with me, but if it differs from me, it is wrong.
That's dishonest. Not just wrong. I may say this is the correct position in law, and if you decide differently, I'm sorry, you're intellectually not good enough as I am. Is very different from saying you're dishonest.
I understand. But let's come back to our subject, which is contempt. I'm going to now come to the second issue you raised. For the sake of the audience, I'll clarify. The first issue is whether the content of the tweets or the cartoons is contempt. And you believe both Kunal Kamra's tweets and Rachita Taneja's cartoons are contempt. And in fact, in Rachita Taneja's case, you say her conduct is disgraceful. It doesn't even pretend to be humor. Let's now come to the second issue you raised, and that is to do with the question, should we bother about these comments from these two to take action against them? Who are they? Do they merit action, even though they are contemptuous? And let me first address that issue like this. There's no doubt that what Kamra has said in his tweets or Taneja has suggested in her cartoons would hurt the Supreme Court. I'd concede that. There's no doubt that it doesn't show the Supreme Court in a good light. But isn't that the point of satire? Surely satire is designed to lampoon, not adulate. And the Supreme Court, which comprises elderly, wise judges, all in their 60s, should be broad enough and generous enough to accept that they will be lampooned and to take it on the chin.
The this take it on the chin is in fact a phrase an English judge had used, and I had recently, for some other purpose, looked up the very so many cases, and the one which is the most oft quoted is the case uh, of the spy catcher, where the Times, when the House of Lords injuncted the Times from carrying the spy catcher serialized, they called them the five old fools.
Can I correct you, sir? It wasn't the Times, it was the Daily Mirror 1987. The
Yeah, yeah,
headline
right.
was "You Old Fools."
Yes, and the somebody asked one of the low lords saying, "Oh, is this not contempt?" He said, "How?" He says, "Five is accurate, old is accurate, fools is a matter of opinion." So, if you say the Supreme Court judges have lost, I have heard, I have sometimes said that the way the judges today decline bail in some cases make me feel that they have lost their soul. Now, that is a strong criticism. That is not undermining the institution. I'm not calling the judge corrupt. I'm saying you must have a sensitivity to human suffering, like Krishna Iyer did, who said bail, not jail, should be the rule.
Well, I,
Now, but that's a criticism of the way you are working of your jurisprudence.
so are you suggesting that when the Daily Mirror in 87, after the spycatcher judgment, called the judges concerned "you old fools," that was criticism, not contempt, and
Yes,
therefore the judges could take it on the chin because it wasn't contempt?
because it was a criticism ultimately of the judgment that you have taken such a narrow, blinkered view of what constitutes public interest, that you are fools. Now, if somebody said by granting or refusing a bail, by refusing bail to say those urban Naxals or by granting bail to Arnab Goswami, the Supreme Court has shown complete lack of sensitivity to human rights, or the Supreme Court in not granting bail has shown complete lack of sensitivity, what's happened to these judges, etc. You are ultimately using strong words, but your target is a judgment. Is their conduct in the area in which they work.
Let me
You're
then
not questioning their character.
Let me then give you another example, once again from Britain, where you are in fact a prestigious Queen's Counsel, and this time it is after the 2016 Brexit ruling. On that occasion, the Daily Mail called the concerned judges enemies of the people. Now, that's
Yes,
not by any stretch of imagination criticism of the judgment. That is a comment on the character, quality, and presumably
no,
affiliation of the judges to the people. It's a character
this,
comment, not a
this, no,
criticism of the judgment.
this
Yet
is
it wasn't
this is
considered contempt.
this is the most telling example. This is the most telling example of harsh words which seem to be contemptuous, but what my view is it will not be contemptuous. Let me explain to you why. The two decisions of the UK Supreme Court, which have been relating to matters of politics and in the political domain, I don't mean politics in its narrow pejorative sense, I mean politics in the governance of the country, are the Brexit ruling, followed by the ruling by which they put Parliament back, saying the Prime Minister's advice to prorogue Parliament to get Brexit through was wrong. At that time, when you say the Supreme Court judges are enemy of the people, what you're saying is by construing the Constitution in this way, they have given a judgment which is contrary to public interest. Now, that is Daily Mail's perception of what is public interest and public good. The Supreme Court said we cannot confer on executive government such wide powers that they could change the British Constitution. And that is why the Brexit ruling saying you have to take it back to Parliament.
Can I interrupt? You're really saying that even though the language was judges are enemies of the people, you're still saying that this was in fact criticism of the judgment, criticism based upon how the paper's interpretation of the interests of the people was different to the judges. It wasn't a comment on the character and quality of the people who are judges. Because to me, enemies of the people is personal criticism, not contextual criticism of the judgment.
The point is, nobody has suggested that the judges decided. Let me give you the example. If somebody said the judges decided this way because they hate the conservative government, ah, now you're saying there was a motive. One is a challenge to your intellectual integrity, saying you are giving judgments by construing public interest so narrowly or so widely, depending on which way you look at the decision. And therefore, really, what you're doing is going to hurt the people of the UK. We've heard these arguments before. The Supreme Court has set aside certain decisions. Even when the Vodafone judgment came, there were criticisms saying Supreme Court is an enemy of honest tax-paying people because it is allowing this kind of tax evasion to get away and so on and so forth. So we've heard this kind of criticism. Do I approve of this language? I don't, but then it's the language of the Daily Mail. It's not the language of the Guardian. The point which I'm trying to make is ascribing motives which are not purely motives of an intellectual construct of the judge, but motives that you have acted either with favor or without, or you have acted with fear.
Okay.
That is where contempt steps in.
Let me then put yet another example, once again deliberately taken from a British judge. Over 40 years before Britain actually abolished the law of contempt, one of Britain's greatest judges, Lord Denning, who was master of the rolls at the time, said this in 1968 of the law of contempt. I'm quoting him. Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity, nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something far more important at stake. It is no less than freedom of speech itself. It's the right of every man in parliament or out of it, in the press or over the broadcast, to make fair comment, even outspoken comment, on matters of public interest. And then Lord Denning added, we must rely on our own conduct itself to be its own vindication. Surely that should be the attitude of a wise judge rather than a desire to punish because it's the best way of protecting your hurt ego.
If a judge ever was to rely on, or if a contempt decision is based on a hurt ego, it is wrong. And one of the reasons why why the British felt it is best to do away with this kind of contempt jurisdiction, have it only in defined cases where people disobey court orders, is that it becomes very difficult. And the discussion which you and I are having underpins this issue. This subtle distinction between enemy of the people being a criticism of the judgment versus enemy of the people being a criticism of the institution is sometimes too fine for a clear understanding. And therefore, the use of contempt jurisdiction at times clearly gives a impression that what you're really doing is you're nursing a hurt ego. That is why the English system has done away with this, even in cases few and far between where there may be contempt. But they have felt on the broader perspective, and that's what Lord Denning says, that for our dignity, we must base itself on our conduct. Our dignity must lie on much surer foundation.
Why shouldn't that apply to judges in India?
And let me give you an Indian example. There was a very nasty speech which Mr. Shiv Shankar gave, damning the Supreme Court. And what did Justice Mukherjee say? We treat this with contempt, not in contempt.
Why should that not apply to Kamra and Taneja? I know the Supreme Court hasn't decided.
Which is now you're going into my second silo. Should the court really bother about this?
And your answer is clearly no.
I won't, I don't, Karan, I'm not on social media. I don't know how important these people are. Are these really? See, let me give an example. If the leader of the opposition in a public speech were to say that the Supreme Court is pro-ruling party in the Indian context, versus Mr. Kamra saying so, or some young student who feels strongly saying so, it will make a world of difference. If the Home Minister says that the judges are acting in a particular way, versus somebody who wields the Twitter handle and may have a million followers saying it, it makes a world of a difference.
You're making a very important point. If the Supreme Court can shrug its shoulders and move on, when Shiv Shankar, who was a senior politician, was sharply critical and you believe contemptuously so, if then they could shrug their shoulders and move on, your advice is shrug your shoulders and move on when it's Kamra's tweets and Taneja's cartoons. They aren't worth the effort of prosecuting.
In a completely hypothetical situation, if I was sitting on the bench, my first question would be, who is he?
Quite right. Let me then one last time quote someone. This time I won't quote a British judge. I'll quote an Indian judge. In 2008, Justice Markandeya Karju, whilst he was a Supreme Court judge, gave a lecture on the subject of contempt. And this is what he said. The test to determine whether an act amounts to contempt of court or not is this. Does it make the functioning of judges impossible or extremely difficult? If it does not, then it does not amount to contempt, even if it is harsh criticism. The only situation where I would take action was if my functioning as a judge was made impossible. In other words, if the functioning of the court and the functioning of the judge stops, then I will deem it contempt. But if not, whether it's my character or my judgment, I will ignore it.
We have had situations, Karan, where, for example, politicians start a political campaign against a issue pending in court, or something like that, where in one sense it's what Kachu is saying, where your independent functioning, because ultimately the court depends on public faith and public belief in the institution. Now, if in a particular situation a person who enjoys that kind of position to be able to influence public opinion is rousing public opinion against the institution, you may say you're making my functioning impossible. It is in those cases of few and far between that the contempt jurisdiction should be used, not as a cane to rap people on the knuckles.
So you agree with Justice Karchu in this instance?
Well, I would put it differently, but broadly, yes. The ultimately it's the enormity of the situation. As I said, my second silo, it's the enormity of the situation. If somebody is starting a public campaign against the Supreme Court versus some chap writing a tweet, and my first question, if I theoretically, fortunately it's never going to happen. If I was a Supreme Court judge, my first question would be, who is he?
Absolutely. And therefore,
why should we be reading this?
And therefore, to extrapolate from what you're saying to Kunal Kamra and Taneja, you're saying two things. First of all, who are they? Why do they matter? And secondly, what is the impact of whatever they've said or done? It hardly matters to anyone.
But only one caveat I would add. Indian media needs to be careful of what is called the principle of republication. If you pick up that cartoon and start running it, if a mainstream newspaper editor starts running that cartoon on a regular basis, things may start changing. But today, this tweet came, it went away, it may have caused a few giggles and a few animated debates on maybe Facebook, Twitter, Instagram, whatever. It's over. We are now worrying about something else. We are worrying about Greta Thunberg and what she did. So, we moved on. Who cares? Let's get on.
You've been very, very clear. I'm just summing up for the audience the two important points you've made. As you say, they're two separate silos and keep them separate. First, the content of Kamra's tweets and Taneja's cartoons were decidedly, definitely contemptuous. Taneja's cartoons, very particularly so. But in both cases, you say, who are they? Why are we worried about them? And what impact have they had? And so even though their cartooning or their tweeting is contemptuous, you believe Shrug your shoulders, move on. Don't give them more attention than they deserve. Don't bother to prosecute them.
On a lighter vein, if I may tell you a very interesting discussion when I was Solicitor General, much younger, there was something nasty. I went to the Prime Minister, Vajpayee ji was Prime Minister, and said, "Sir, we should do something about it." He said, "Mr. Salve, today's newspaper, tomorrow's Bhelpuri paper."
Absolutely.
He says their news is today's news, your reply is tomorrow's news, their rejoinder is day after's news. You file a case, it is 5 days news. आपने एक दिन का न्यूज 6 दिन का न्यूज बना दिया.
That's very true. We're coming to the end of this interview, Mr. Salve. Let me then end by asking you this. Has the time come either for the government to abolish the law of contempt, which the British did in 2013, or for the Supreme Court, which is often a more wise organ, to substantially read it down?
I think the Supreme Court will do it. First of all, in India, considering where we are today, I don't think this is really a time for legislation, because what really one should do is trust the court in going back to the drawing board and coming down and saying, we are going to treat it in the same spirit as Justice Mukherjee treated the Shiv Shankar story.
When you said you think the Supreme Court will do it, are you also saying the Supreme Court should do it, i.e., should substantially read it down?
Speaking for myself, I never believe in a binary conclusion. This is my view in the matter.
Well, absolutely. But in your view, because you are a lawyer who's highly regarded, should the Supreme Court read it down?
I think the court should, frankly, best. There's one very interesting thing which one Supreme Court judge told us. You should decide an issue only when A, it is important enough, B, when the time is right. Right now, shutting the door on these two contempts and moving on is all that is required.
But looking down the road, because other cases could come up, should the Supreme Court read it out? I know I'm deliberately pressing you, but I'm doing it because your opinion is highly regarded.
I would take it one step further, Karan. There should be no occasion for the court to read it down. It is entirely in their hands when to start contempt.
You're a brilliant lawyer, but you turn my question on its head. Whether there's occasion or not depends upon the people of India and how they tweet and joke. But when that happens, should the Supreme Court read it out? My last time to get you to say, you said you hope it will happen.
This doesn't call for a judgment. It calls for saying not a fit case for issuance of notice, dismissed. That's all that is required. The message will go.
Okay, that comes very close to answering my question, although not quite. I'm interpreting it nonetheless. You're suggesting without saying explicitly that the Supreme Court should read it down, and the smile on your face and your nodding head is concurrence, I should assume.
You can sometimes, one sentence can be more effective than 50 pages of unnecessary verbose wisdom.
That sounds like a second bit of concurrence from you. My very last question. Should judges bear in mind, I'm talking about Supreme Court judges, that their court is supreme, not because it's infallible, but because it's final? And secondly, should judges bear in mind that they deliver justice, they don't embody it, and therefore they shouldn't take themselves too seriously?
In fact, you're absolutely right. They are right because they are final, not the other way around. Secondly, they don't, as one, again, a very famous judge said, we don't deliver justice, we administer the law. So they interpret the law, they apply the law. Justice has to be delivered in a joint attempt between Parliament and the courts. And I think this rather inflated notion, which unfortunately has come into being, no courts in the world are as much in the public gaze as the Indian courts. And sometimes I do feel judges write certain judgments only hoping that Karan Thapar will next day put them on the front page. So it doesn't happen in any other system in the world.
But now, Mr. Salve, I'm interrupting you. You're suggesting that some judges play to the gallery.
Yes, there are some judgments which the only explanation for which can be that this is playing to the gallery. We have had those kind of judgments. So I personally feel I mean, one judgment which has recently been stayed by the Supreme Court, which came from Madhya Pradesh, I thought it was playing to the gallery. I don't want to say more because the case is pending in the court. So I personally feel, yes, you're right. We all have to remember, not just the judges, that the Supreme Court reads the law, interprets the law, applies the law. And if there is a action which emanates, which in our sense of justice doesn't measure up, something has gone wrong. But then the judges also are human. They could have made a mistake. They may have made a mistake. Don't call them corrupt.
All right. But the very important point that I'm teasing out from that last answer is the one that you made, that sometimes judges do play to the gallery. Sometimes judges write judgments with next day's papers or that evening's television discussions in mind, and that is something they must avoid at all costs.
Supreme Court in judgments has said that be very careful of what observations you make. You wield the pen, you may damn people's reputations. So this is a old problem, right? I was yesterday reading a judgment by Justice Bhagwati in the 1980s, coming from Madhya Pradesh, in a liquor case, where he said, be careful of what you say about people.
Well, I hope the judges are listening to you. They hear you in court every day when you're arguing in front of them. Today, you're giving them sage advice. Not quite a rap on the knuckles, but certainly a politely delivered, I might call, admonition. And I hope they listen to you.
These kind of things, the kind of pressures our institutions work under, the kind of cases which they are taking onto their plate. Sometimes there is this kind of a problem.
I'm going to interrupt you. All good, important people work under pressure, lawyers and journalists as much as judges. You have to learn to deal with it, not make it an excuse for the fact that you have been intemperate. But let's leave it there. I want to thank you for this interview, for making time for me. Take care. Stay safe.
Thank you. Bye-bye.